I've got a wild story out of New York involving automatic speed camera tickets being thrown out, and it's one you'll want to hear about. It comes from an article written by Stephen Rivers over at roadandtrack.com. The headline: New York issued 26,000 speeding tickets totaling $1.3 million. And now a judge says the traffic court had it all wrong. Here's what happened. In the fall of 2024, the state of New York deployed an automatic speed camera system along a stretch of I-490 near Rochester. In just 25 days, roughly 26,000 drivers were ticketed in that work zone. 26,000. Out of all those drivers, only 239 chose to fight their tickets in court. Of those 239, 40 ended up winning their cases. But one particular driver may have opened the door for many more. This individual received 3 separate tickets in that work zone, totaling about $275 in fines. Instead of simply paying them, he decided to contest them. He lost at the initial hearing, but he appealed, and that's where things got interesting. According to local coverage from Wham! News in Rochester, the driver described the original hearing as feeling almost like 3-on-1, saying it seemed as if the prosecutor, the judicial hearing officer, and even the clerk were all aligned against him. Now, that raises eyebrows immediately. The Monroe County judge who reviewed the appeal saw it the same way. In his ruling, he wrote that the proceeding had little resemblance to a court proceeding, and that there was barely any evidence presented. That's a pretty sharp criticism. The driver reportedly went in thinking about the rules of evidence. And he had a point. In a traffic case like this, the burden is on the government. The defendant doesn't have to prove innocence. The prosecution has to prove the violation. But according to the record from the lower hearing, it appeared as though everyone in the room was pushing against the defendant, and one of the more troubling details involved the court clerk. The judge found that at one point, the clerk interrupted the proceeding, challenged the defendant, told him what the law was, and even made a legal determination about the case. Let's pause there. Court clerks are not supposed to do that. They don't interrupt proceedings to argue legal points. They don't explain the law to one side. And they certainly don't make legal rulings. That's the judge's job. Or in this case, the judicial hearing officers. Now, I looked into what a judicial hearing officer is in New York. In some states, there are administrative hearing officers who aren't lawyers. But in New York, judicial hearing officers are licensed attorneys. They've been to law school. They should understand courtroom procedure and evidentiary rules, which makes this situation even more concerning. The appellate judge also criticized the judicial hearing officer for leading questioning of the defendant throughout much of the proceeding. That's another red flag. Leading questions can shape answers and undermine fairness, especially when directed at someone defending themselves. So what happens next? The ripple effect could be significant. Those who pleaded guilty or no contest and paid their fines are likely stuck. Once you pay and close the case, it's generally over. But the 239 people who challenged their tickets may have grounds to appeal depending on timing. The appellate ruling came down on April 8th, so procedural deadlines will matter. Think about that. 26,000 tickets issued. Most people paid. A small fraction fought. And one person who appealed may have exposed serious procedural flaws. One thing I always point out in cases like this is how intimidating the appeal process can seem. The driver initially lost. At that point, he probably had to decide whether to file an appeal, pay additional fees, possibly post a bond equal to the fines, and risk losing again. If you lose an appeal, you're often out the appeal fee and the fine. If you win, you get the fine back. But that's a gamble most people won't take over a $100 or $200 ticket. There's another aspect of this case that caught my attention. In Michigan, where I practice, nearly every courtroom proceeding is recorded automatically, either audio or video. Back when I started practicing law in 1991, some courts used stenographers who spoke into those mask-like recording devices. Others used stenotype machines. Today, digital recording is common. I've heard that in some states, certain lower-level proceedings aren't always fully recorded. That's problematic. If there's no record, how do you appeal? An appeal court reviews what happened below. Without a record, sometimes you have to try the case all over again. de novo, from the beginning. That seems inefficient to me, but apparently some jurisdictions think they save enough money by not installing recording systems to justify it. In this New York case, there was a record, and that's how the appellate judge could see what went wrong. Now, let me tell you a quick story that illustrates why courtroom procedure and cross-examination matter. I once represented someone at an administrative hearing where a police officer was testifying. He was reading from his report. It became clear he didn't independently remember much about the incident. A couple of times, when the hearing officer asked him questions about details not in the report, he paused, thought, and then suddenly recalled very damaging facts. Facts conveniently not documented. When it was my turn to cross-examine, I asked if he could testify without looking at the report. He said yes and closed it. So I asked him a simple question. What color was my client's car? The hearing officer objected, saying the color was irrelevant. But credibility is never irrelevant. If a witness claims to remember critical details, yet can't recall basic information like the color of the vehicle, that's important. It speaks to reliability. In law school, when I taught trial practice, I used to give students a hypothetical. If a witness testifies in just 3 sentences, how many questions can you ask on cross-examination? Some would say 3 or 4, but the answer is many more. You can ask about eyesight. Were you wearing glasses? How far away were you? What were the lighting conditions? You test perception, memory, and credibility. In that administrative hearing, the officer couldn't recall basic facts without his report. That would have been powerful cross-examination material, but the hearing officer cut it off. Procedure matters. Back to the New York case. The idea that a clerk would chime in with legal opinions or challenge a defendant on the record is highly unusual. In every trial transcript I've ever reviewed from my own cases, the clerk speaks only when necessary, typically to call the case, administer an oath, or mark exhibits. They don't debate the law. They don't question defendants. They don't make rulings. The appellate judge in this case essentially said the lower proceeding didn't resemble a proper court hearing. And that's troubling, because 26,000 people received tickets, most paid without contesting. And if the process itself was flawed, thousands may have paid fines without receiving a fair hearing. This also raises broader questions about automated enforcement systems. When tickets are issued by cameras at scale, people tend to assume the process is mechanical and accurate. But the human component, the hearing process, still needs to meet basic standards of fairness and evidence. Just because a system is automated doesn't mean due process disappears. And whenever someone says, "If you weren't speeding, you wouldn't have a problem," remember, constitutional protections aren't about shielding wrongdoing. They're about ensuring that the government follows proper procedures when accusing someone of wrongdoing. The Fourth Amendment, the right to due process. Those exist precisely to prevent shortcuts. In this case, one driver refused to accept what he felt was an unfair process. He appealed, and the appellate judge agreed that the hearing had gone off the rails. Out of 26,000 tickets, one appeal exposed a deeper issue. That's worth paying attention to. Most people simply pay the fine and move on. And that's understandable. It's quicker and cheaper than fighting. But sometimes pushing back reveals that something wasn't done properly. Questions or comments, feel free to share them. Let's talk about it.